Bismillah ar-Rahman ar-Rahim. Your Excellencies, esteemed dignitaries, and honored guests, welcome to Al-Faisal-University. We would like to welcome our guest, His Honor Justice Kuno Tarfasser, who is sharing his insightful experience from the International Criminal Court, where he assumed office in March of 2009 as its Vice President for 11 years. Justice Kuno studied law at the University of Edinburgh and the University of Padova. Prior to his appointment to the ICC, he had an extensive legal career in Italy as a prosecutor, including holding the office of Chief Public Prosecutor. Having recognized his achievements, he was awarded an honorary doctorate degree from the University of Edinburgh in England. Please join me in welcoming Dr. Kuno. Welcome, Doctor, to Saudi Arabia and Al-Faisal University.
Well, thank you very much for this introduction, Dr. Torki. And thank you very much for having me here in Riyadh. It's my first time in Saudi Arabia. And I'm only here for 24 hours now, but I'm already quite excited about what I've seen and what I've learned. And I'm looking very much forward to the next few days I will stay in this country. I'm very much honored to give a lecture here in Riyadh, in a country which is developing very, very quickly, and as I can judge, in the right direction, I would say. Although it has not ratified the statute of the ICC. But we will come to this in a minute. I'm, of course, very open, and I always say what I think. Very open also to questions after, if you have any. But I thought that before starting with questions and going into details and what your interest might be, I will lay the factual and legal basis. I try to lay the factual and legal basis of the ICC, an institution I was, as Dr. Torki said, I was 11 years, which is a long time in life, 11 years part of. And I'm very much honored to have been part of. I was asked to talk about the strength and the challenges of the ICC. And I think the ICC has both, has some strength, but for the time being, it has more challenges to face. And I will say this from my perspective, having lived inside the ICC for all these years. And the photo is the seat of the ICC when I arrived in The Hague. Now, in the meantime, they have construed another court. We will see it at the end, the new premises of the court. But this is how it started. There it is how it started in 2002. The origin of the ICC, and I do not go back to Nuremberg and ICTY and whatever, because I want to keep it short in order to let space enough for questions. The origin of the ICC is based in Rome, in my country, where in June and July 1998, we had the UN diplomatic conference with the aim to establish a treaty, to establish a court. And this treaty was adopted on 18 July 1998. And it is called the Rome Statute. We are working on the basis of what we call the Rome Statute. And I think this was the first miracle, because, as you know, experience says that UN conferences do not end always very luckily and very happily and with the envisaged outcome. But at that time in Rome, we had this success. And I've seen it from the perspective of 2025. You can only, well, not only 2025, also before that, you can only think that it was a miracle. But the second miracle, which is even bigger, happened in 2002, only 4 years later, when more than 60 states already had ratified the statute. And as you know, the ratification process in each country is different, but it's for sure not a short one and not an easy one. But in 4 years, more than 60 states had always deposited its ratification at the UN. And therefore, according to the statute, after the ratification of 60 states, the statute entered into force. And this happened on the 1st of July, 2002. This means also that the ICC is a very young institution for being a judicial institution, which is normally a very heavy, a very slow, and a very conservative one. So the ICC, what we have today, and this I say it from my experience, is for sure a permanent judicial institution, to the contrary to Nuremberg, ICTY, ICTR. They were not permanent judicial institutions, but so-called ad hoc institutions. We are an independent, and this, I want to underline this, an independent institution. And if I say we, is because I always feel, I still feel being part of it. So sometimes I don't say they, but I say we. We are an independent institution, and I can assure you that this is real independence, meaning I have a lot of examples of what maybe powerful nations would have expected from the institution, but the decisions were different. So we are an independent institutions. We are based on a treaty, meaning on the consensus of the international community, on the treaty and not a creation of the UN Security Council, as it was the ICTR, the former Yugoslavian Tribunal, and the Rwanda Tribunal, or the hybrid tribunal. Most of them were created by the UN Security Council, meaning that it's very much a political institution, much more than a treaty-based institution like the ICC. The only link we have, which could think of a lack of independence or a minor independence, is given by the fact that we are, from the administrative point of view, we are linked to the UN. But this is something we need for a better administration of the court, and which has nothing to do with the judiciary itself. Today, we have 125 states which are parties to the Rome Statute, which have ratified the statute. And here I've listed them in relation to the 5 macro regions in which is the world, the UN divided the world. So you'll see we have nearly all of the European countries, while other states means Australia and New Zealand. We have very many African states. We have not so many Asian states, but okay, 125 is still more than 2/3 of the countries in the world, which are, as you may all know, 193. I also can have witnessed that in the first half of my tenure, from 2009 until 2015 around, we had every year 2-3 new countries ratifying the statute, entering into the so-called ICC family. In the second tenure, from 15 until 20, this has slowed down very, very much due to probably the situation, the geopolitical situation, which was in a fast change. What are the goals of this ICC? The goals of the ICC are summarized in the preamble of the statute, which I took out an excerpt of this from the preamble, which talks about the most serious crimes of concern to the international community must not go unpunished. And in order to put an end to impunity for the perpetrators of these crimes and contribute to their prevention of the crimes, the ICC was established. This was the basis and the reason why the then international community in 1998 established the ICC. Now, rapidly, the legal framework. Many people also at home, back in Italy, lawyers, they ask me, what law do you apply at the ICC? Well, it's written in the statute at Article 21. It says, first of all, you apply the legal instruments of the ICC, which is the statute. But just with the statute, you can't conduct a trial. So the first, as soon as the statute was adopted in Rome, they started to draft that was called the Rules of Procedure and Evidence, which is really the manual on which we work in the trial. And then the first judges, and the first judges had no work to do, of course, they started to draft the regulations of the court. So these three types of legal instruments are the basis on which we use to conduct the proceedings. But of course, we go back also to international treaties. Just think about, if you talk about war crimes, you have to go back to the treaties to the international humanitarian law, and to the Geneva Conventions, to the Hague Conventions, and therefore, of course, they come in as law which we have to apply. Or think about immunities, diplomatic immunities. The Vienna Convention of 1963 on diplomatic immunities have to be applied in case, and we had many of them, or well, some of them, which implies accused people with diplomatic immunity. Then, and we have another source are the general principles of laws derived from national laws and from legal systems in the world. And believe me, it's not the first time that I say it. I have said this all the time, that when I said this all the time, that when you go to the legal systems of the world, obviously the legislator in Rome thought about common law and civil law. And I always said, but what would happen? And on the basis of civil law and common law, the regulations and the statute and the rules were drafted. And I always say, and I say this since 15 years, but what if we reach universality, meaning that all countries ratify the statute, what about the Sharia, for example? They will also ask to be part of this, the principles, part of this, of the applicable law. And there we could have some conflicts. The last source, we are applying our own precedents, which I, as a judge, I felt most exciting part of my job, because I create law somehow. And just to make an example, I'm the first international judge who ordered and applied telephone intercept in a case. And you don't find the word telephone tapping or telephone intercept in the whole legal framework of the ICC. But you can construe it on the basis of your, on one side of your experience, and on the other side of the general principles of law on which the ICC is based. So I construed this. I authorized telephone intercept on the basis of telephone intercept. 5 people. I arrested 5 people, and they were all convicted for the crimes they were arrested for. The ICC is based on the principle of complementarity. And the principle of complementarity just means that the ICC has no exclusivity on international crimes, and we'll see later in a few moments what international crimes are, but has a jurisdiction over international crimes as a tribunal of last resort only, meaning that only if the state which would be competent in first instance is unwilling or unable to genuinely, this is the adjective used by the statute, carry out the proceedings, then the court jumps in order to not let the crime be unpunished. This is the idea behind it. First, the jurisdiction, the national jurisdiction comes first, and if the national jurisdiction does not activate itself, the ICC jumps in. This is the idea behind it. And this is also the reason why the ICC is a very small institution. The judges were only 18 judges, and 1 prosecutor sided by 2 deputy prosecutors. So obviously the idea behind it is first the states come, and I jump in only after. That's why we are all the legislator in Rome created just a small institution, not a big one. We say in the preamble it said the most serious crimes of concern to the whole international community. We all know which are the so-called international crimes. Crimes against humanity, war crimes, genocide, and crime of aggression. I will not now, because this would annoy you probably, and I will not go into all the crime, what they mean and what they imply, but I would just point out one particularity. Why? The question behind it is the following: why are those crimes called international crimes, and therefore also in the jurisdiction of the court? Crimes against humanity can be murder, but why is a murder a crime against humanity, or not just a murder, which obviously would not fall into the jurisdiction of the court? What is the element which changes a crime from a national crime to an international crime. It is the contextual element. That's why I wrote it on the slide. And what is the contextual element? Everybody who is a criminal lawyer knows that a crime consists from an objective and a subjective element. The objective element is the fact, and the subjective element is the wish to commit the crime. So the dolus. The international crime needs a supplementary element, which is the contextual element. And I make just one example in order for you to understand. And I use the war crime. The contextual element of the war crime is the war. So if the crime happens outside the war or is not related to the war, it can't be a war crime. So this is the contextual element. I will not go in to the contextual element of the crimes against humanity and the genocide, because it would take a lot of time. But just, there must be a supplementary element. And the first thing an international judge must think of is, do we have in this situation the contextual element? Is the contextual element given? This is what first has to deal with the international judge. The jurisdiction by the court is given, the court has jurisdictions over the crimes committed on the territory of a state party, of one of the 125, or by a citizen of one of the 125 states. This is the basic legal provision. But there is another possibility to ground the jurisdiction of the court. If the state was not part, because has not ratified the statute, has accepted the jurisdiction. Like, just make an example. In Ukraine, when the war first in 2014, and then 3 years ago, when in this long phase, the Ukraine was not a state party, but the Ukraine always accepted the jurisdiction of the court. And under this provision of the acceptance of the jurisdiction of the court, the prosecutor initiated the evidence. Another example was, at that time, Ivory Coast. Ivory Coast had not ratified the statute, but had accepted the jurisdiction. And unlucky him, the president who accepted for Ivory Coast the jurisdiction of the court, was the first arrested a few years later. But there is what I call, not we, a special jurisdiction, which doesn't need any particular precondition, because it is based on the UN Security Council, on a resolution of the UN Security Council. Meaning that the UN Security Council can decide that, or can refer a situation to the court, and this has happened also twice, and it can refer a situation to the court also against in relation to states which have never thought to ratify the statute. And this has happened twice already. The first time in the Sudan Darfur case. Sudan is not a member state, but the Security Council has decided to refer the situation in Darfur at that time to the ICC. And the second time it happened in, I think, 2011 in relation to Libya. Libya has never even thought to ratify the statute, but the Security Council adopted unanimously, which is very important, meaning also with the veto, with the positive vote of the veto countries, has referred the situation of the Libya to the ICC, and which obviously brought them to the arrest warrants against Gaddafi, which I signed. The activation of the trigger, the activation of the ICC can be done through three so-called triggering mechanisms, which is the referral by a state party to a state party referring the situation of another state party, which was, for example, done in the case of the Ukraine, where 29 state parties referred the situation, the aggression by Russia to the Ukraine to the prosecutor. As I said before, the referral by the Security Council, as I said before, it happened in Sudan and Libya, and, which is very interesting, also the prosecutor can motu proprio, on his own, acting on his own decision, open an investigation. But the funny thing about it is, and for me, I was a prosecutor before going to the ICC, when I read this, I was surprised, because the prosecutor can only investigate if he is authorized to do so by the judge, by the judges, by the pretrial chamber. And then I went back to the story, and the story is very, very interesting, because this is a very political issue on the power of the prosecutor. Which power has the prosecutor? So there were states, they didn't want to have a strong prosecutor, and there were other states wanting to have a strong prosecutor. And on this very political issue, there was the conference in Rome risked to fail. But diplomats are here to find solutions also to the most complicated issues. So when it was very, very close to fail on this particular issues, some of diplomats came together and found out this solution. Let him do motu proprio investigation, but control him through the judges. And therefore, we have this strange situation where a prosecutor can only investigate on the basis of an authorization by the chamber. Very quick principles of responsibility. The ICC is a criminal court, and therefore the principle of responsibility is the individual criminal responsibility. It's not the state responsibility. We go only for individuals who have decided in some instances to commit the crime, or have ordered the crime, or committed the crime, it doesn't matter, but it must be an individual. Article 25 of the statute is really very, very complex in this issue, and the same complexity is for Article 28, which talks about the command responsibility. When is a commander responsible, and when can a soldier not deny his own responsibilities? It's under 28. They're really two very impressive from the substance articles. And then we have, and this is very interesting, the irrelevance of official capacity. And this created a lot of disputes also within the court, when it came to, especially in cases when presidents or personality with immunities are involved, which can happen quite often. I mean, and Article 27 says that vis-a-vis the International Criminal Court, you cannot say, well, I have immunities, but also this is not so clear, because nothing in law, we always know that law is an opinion, so at the end a judge decides, but the official capacity, to my understanding, and in this sense, I have also drafted and signed decisions, is that vis-a-vis the court, you cannot say, well, I have immunity. You're a person like any other person can be responsible, and that's written clearly, I think, in the Article 27 of the statute. I think the last one is something very particular for international criminal law, because the ICC is the first criminal institution, or the first judicial institution which admits to participate victims in the proceedings. I must say, when I first arrived in The Hague, and obviously knowing this, I was very in favor of this participation of victims. The way it is handled in the statute makes it very difficult, because the statute foresees that the participation is a singular participation, not by communities, for example, which means that for crimes, for war crimes or crimes against humanity, for international crimes, you have potentially thousands and thousands of victims, which obviously goes to hinder the trial itself. It slows it down, because you have to look at each request to participate. So I think there would be a lot of work to do on this issue. And but I think at the end, to have victims participating, however, is an added value to the court, because you know that there is this saying, no peace without justice, and I believe then you can handle it. It depends how you handle it, but I think it's something which comes very, very true. Now I'm finishing, because the origin was strengths and weaknesses, and what are the challenges? Well, I think, first of all, the strengths is, first of all, the existence of the institution. I mean, the fact that I'm here, that you are interested in the institution, means that there is something to talk about. When I studied international law back a few years ago, I say a few years, but some more than a few years ago at university, even to think about a criminal judicial institution was, if one would have suggested it, the professor would have said, you're insane, huh? And nobody would have thought, and I was the last one who would have thought that once I would be a judge at an international criminal court. But therefore, the institution itself is an added value, is a value as such. Then I think another value which I witnessed is the development of international criminal law. I mean, international criminal law can only be developed by doing every day, and by doing on the basis of internationally recognized principles of human rights, of rights of the defense, of rights of the accused, to try to find a balance, which is not always easy, but trying to find it, and you find it only by doing it. Then the third added value is the development of the national legislations. Just think about all the countries who have ratified the statute somehow must also go in line with the. It's not true, of course, because you can't do it from one day to another. But the development in that direction is given by the fact that states are part of a community. And this community is based on principles which somehow, at least in theory, but in a developing reality, are common. And I think these are values. Obviously, we have weaknesses, and I always say that every day I woke up, I was excited to go to the court because you feel very strong, one of 18 persons in the world doing this job. You feel very strong, you feel very important also. And then, you at the end of the day, you left the court and you were frustrated because it was not really, you could not really achieve what you wanted to achieve in the morning. Yeah. So, of course we have weaknesses, but we exist. And the weakness is the length of the proceedings and the high cost of the proceedings. Yes, true. But if you want a fair trial, if you want a trial which guarantees the rights of each party involved, which implies also language and lots of things, you have necessarily a long proceeding and necessarily an expensive proceeding. I always remember that once I had an accused from Darfur, and I asked him which language he fully understands and speaks, because this is how the statute labels the understanding. The language you fully understand and speak, fully. And he answered, Zagawa. And yes, I've never heard about Zagawa. And then I realized, after making some research, that Zagawa is only a spoken language in a part of DRC, not of DRC, of Darfur. And obviously, it was not easy to find somebody who can come for some months to The Hague to translate from English or French into Zagawa, and in any case, it's extremely expensive. So there are weaknesses, but I would say necessary weaknesses. But the real weakness we find out now is that the ICC was not established for times like we are living in now, not for conventional wars. Think in 1998, nobody thought that there would be a war somewhere. I mean, a conventional war between sovereign countries. The conflicts were localized, between in normal civil wars within the state, but not really. So this is the weakness we realize now, because at that time, if in 1998 somebody would have thought to establish a court for times of war, they would have said you're mad, because there can't be any war anymore. So the challenges, and this is the last slide I promise, I think in short term is to try to get through through these critical times as unscathed as possible, which is already a big challenge. I mean, the clouds over the ICC are not very, are quite heavy with the rain. In medium term, to improve cooperation. I mean, you know that the ICC has not his own police. So in the statute, it is written that states who have ratified the statute must cooperate. Then if you go to see Italy, what happened in Italy just last month, and you see that not even Italy cooperates with the court, then I must say I have some doubts. I don't know if you've heard about the case of end of January, what happened in Italy, that Italy did arrest a wanted person from the ICC, but then instead of flying him to The Hague, they flew him back home. And this was no doubt a lack of cooperation, a violation of the obligation of cooperation. I said this very loud also in many interviews and television, but the broader sense of it is if the country who has given the birth to the statute does not cooperate, then I think I'm not very optimistic about the future. And I'm not optimistic also about the long term, is that to reach universality. I think the first thing we have to do is to overcome this period without being killed, which could happen. I hope not, because I still think, and I'm really very much in favor of international criminal law, but we have to shape it a little differently. But I think that all countries should invest in international criminal law by maybe making a further diplomatic conference, but not to destroy it, but to render it something to render it a player together with politics, together with diplomacy, together with the UN, the security, the blue helmets, together with civil society, to something which can make this world a better world. This is the new premises of the court, and I close here. I took a lot of time, but I'm ready to answer questions if you have any. Oh, yes.
Thank you very much. Feels like I read a book on the subject already. If we have any questions, please go ahead. Yes, do we have any mic?
I don't need mic, I can talk it. My name is Dr. Abrar, I'm from College of Medicine. My two questions, simple questions. Do we have to file a case against the state, or ICC has a power of suo motu to take the notice? Number one.
Now, can you take the mic, please? So it's better.
Two questions. One, do we have to file the case against the state which you're talking about?
Against?
Any state which is involved. Or ICC has a power of taking suo motu notice, number one. Number two, whatever judgments ICC take, how much, it is implemented?
I didn't get the second. How much?
Whatever judgment you people do.
The judgment, the implementation of the
Yes.
judgment.
Yeah.
Okay. Well, the first question is that everybody can make a complaint to the prosecutor. Obviously, if a state party makes a complaint, it has more power than if you make it as a private person, of course, because the ICC, the office of the prosecutor is full of people sending, because then we have to find out if what is said is an international crime, or could be an international crime. Otherwise, we dismiss it, or the prosecutor dismisses it immediately. So it can be also a person, of course.
But you have a power of taking suo motu notice as a ICC.
Oh, taking proprio motu, yes, the prosecutor, yes, he has. But he has to ask the judge if he is allowed to. If he goes motu proprio, he has to ask the judge if sending or presenting a request saying this happened, blah blah blah, and making a motivated request and asking the judge if he can motu proprio go for investigation, and the judge can allow him or can not allow him to make investigations.
And what about the judgment?
No, the implementation of the judgment is as long as the person, the proceedings is open, the person, the detained person, because otherwise you can't go further with the proceedings. So, or you have a detained person, or you don't go further with the proceedings. So, when the proceedings ended with the sentence, convicting him or her to a punishment or jail, then you have the court who establishes relations with other countries where the court sends then the person to fulfill his punishment. So we don't keep the person in The Hague. The person is in The Hague only as long as the proceedings is lasting, and then due to bilateral agreements with other states. I just make an example. I can't remember his name, but this is due to my age. But we have one in the UK. So there is one who was convicted, and Lubanga was convicted, and he's now in the, I don't know now, but at that time he was brought to the UK because the UK accepted to have him.
Hello. I just wanted to ask, given the current geopolitical climate and
The current
geopolitical climate and the questions being raised about jurisdiction and enforcement within the ICC, what do you envision for the future of the ICC, and how do you see it overcoming these challenges in the coming years?
Well, it's really difficult to make a prediction on this. I think we have to overcome at least 4 years, if you know what I mean. But 4 years are very critical, the next 4 years. And I can tell you that I received no longer than 2 or 3 days ago, I was in chat with the prosecutor of the ICC, which is a good friend of mine. And he is saying that the sanctions are affecting his work quite heavily this time. So I think what we have to do is I can't say to keep calm, but try not to overdo, not to go into a conflict, in an open conflict at least, in this situation with the man on the other side of the lake, as we call it from Europe. It's on the other side of the lake. Although I find it absolutely absurd what happens, because a country which has contributed to the Rome Statute because they were in Rome and they actively contributed in drafting and deciding the outcome of the treaty, which signed the treaty because the US, they did sign the treaty. Then they did not ratify the treaty, and for a long time they kept quiet, but now they intervene continuously, and I find it absurd. You don't want to stay with the ICC. Well, keep quiet. No, they want they not only want to intervene, they intervene heavily, and they intervene heavily also in a contradictory way. Because if you think back when the ICC issued the arrest warrant against Putin, everybody was happy. The Americans were happy. Oh, good, this perfect ICC. Huh? Now that the year later, when the arrest warrant was against Netanyahu, now the thing changed completely. And I mean, I think that international crimes have no color. They're not good or bad international crimes, and they're not colored, politically colored. Huh? Crimes are simply crimes, and that's it. And this I have some problems to understand this.
Yes. Greetings. I have a question regarding the following.
Regarding the
following, the United States President recently issued sanctions against the ICC and its members. What is your perspective on the matter regarding this?
Yeah, as I said, I mean, I must say I'm lucky not being there anymore, although I would love to do it. But the thing is just to keep very much onto the law without going into politics or into direct conflict with the person. This is what I think. But
our gathering will be followed by reception, just very close to the law school. So if we gather over there and continue chatting and ask questions, because the seat, I believe, is reserved for another. Thank you very much all for coming.